As a family law attorney in Michigan, I often hear from grandparents who've been cut off from seeing their grandchildren. They ask, do I have any legal rights to see my grandkids? And the answer might surprise you. In Michigan, grandparents' visitation rights, they do exist, but they're limited and they're specific. And so if you're a grandparent fighting to maintain a relationship with your grandkids, this video is going to walk you through exactly when the court might support your visitation request and when they won't. I'm Jim Kraayeveld, founding and lead attorney at Kraayeveld Family Law, and I've been practicing family law for about 3 decades. In Michigan, and every state is different, courts presume that a fit parent's decision to deny parenting time to a grandparent doesn't create a substantial risk of harm to the child's mental, physical, or emotional health. So a fit parent's decision is the end of it. Especially if the parents are married and whatnot, there are various exceptions or specific instances in which grandparents can pursue rights. When the parents are married, they're not. And I'll get to that a little bit more fully in a couple of minutes. So, in order to get visitation, grandparents have to overcome that presumption by a preponderance of the evidence and show that the visitation is in the best interest of the child. The court statute has got another additional level, but that's not been met because case law has been decided that says that's the burden of proof that you have to show the court if you want to get any kind of grandparenting rights, any grandparenting visitation. So the preponderance of the evidence standard is more than 50-50. It's not, like a reasonable doubt, like in a criminal case where it has to be overwhelming. But you do have to have evidence why grandparenting time should occur. So grandparents can seek grandparenting time when there's, for example, a divorce or separate maintenance or an annulment action going on regarding the child's parents. So if that's pending before the court, grandparents have the right to step in and say, I would like to have grandparenting time. If they are already divorced or separated under a judgment of divorce or separate maintenance, again, grandparents may be able to bring a claim for visitation rights. The third option is if the child's parent, who is a child of the grandparent, is deceased. So grandparents have a son who's passed on. That child might be where the grandparents could pursue grandparenting time. The fourth option is that if the grandchild's parents have never been married and they're not residing in the same household, and that's important, and paternity has been established or there's an acknowledgement of parentage, used to be called an acknowledgement of paternity, or where there's an order of filiation in place, the grandparents have the right to file their petition for grandparenting rights. The next option is if legal custody of the child has been given to a person other than the child's parent, or so the child is placed outside of or doesn't reside of the home of a parent, grandparents have the right to pursue visitation rights. And lastly, if in the previous year the grandparent had an established custodial environment regardless of a court order, which means was the child living with you on and off or fairly regularly over at least the past year, where they have an established custodial environment where the child looks to the grandparents for love, guidance, support, etc., just like one of the best interest factors that the court will look at when dealing with custody and parenting time. So, situations where it is worth to file, if you, for example, as a grandparent were providing daycare 2-3 days a week, and dad filed for divorce, mom gets full custody and says, you can't have any contact as the paternal grandparent with the grandchildren. Well, again, if you can show the relationship, you would have the right and have the standing to ask for visitation. Another example is grandparents have frequent contact with the grandkids. They're constantly over. They stay the weekends, they stay overnights, and all of a sudden, your kid is convicted and goes off to prison, and the other parent says, yeah, nope, you don't get to see the kids anymore. No, if there's a divorce action pending or it's been finalized, and paternity, of course, has been established, you have the right to file. Now, unfortunately, one of the things I was mentioning earlier is when you don't have the right to file, your son gets married to a miserable person who wants no contact with you whatsoever and won't let you see the grandkids. Unfortunately, they're married to each other you don't have a right to file for grandparenting rights. Here's another one. Your son is living with his girlfriend and they get a kid together, and dad says, you know what, I'm just simply going to move away and I really don't want to have anything to do with this. You're going to probably not be able to see or have visitation rights with the child unless there's an order of filiation or an acknowledgement of paternity, and it's actually proven that your son had the custodial rights, if you will, paternity rights, parentage rights. And so that's one instance where you wouldn't have standing to pursue a grandparenting visitation request. Now, another one. Mom and dad are simply going to say, you don't get to see the kids, or you don't have standing, and you're not going to be able to show that it's in the best interest of the child that you should have grandparenting time. As long as the parents are fit, their decision is going to be the binding decision. That's the presumption that you have to overcome. And so when you've got two parents who are deemed fit, you're not going to have any success with pursuing visitation rights. There are many technical issues that you have to meet if you're going to pursue it. Sometimes you can, sometimes you can't. And if you ever have questions, feel free to give us a call. Until next time.